Welcome to ABI's webinar on the Supreme Court's June 13 ruling in Puerto Rico versus Franklin, California Tax-Free Trust. The court in substance held that Puerto Rico cannot have a local law dealing with insolvency of its municipalities, even though Puerto Rico is ineligible for municipal reorganization under Chapter 9 of the Federal Bankruptcy Code. I am Bill Rochelle, ABI's editor-at-large. I will be the moderator for today's program. On ABI's website, under the title Rochelle's Daily Wire, I offer up my daily analysis of important legal developments affecting bankruptcy law and practice. The expert on today's webinar is Professor Stephen Lubin, the Harvey Washington Wiley Chair in Corporate Governance and Bankruptcy or Business Ethics at the Seton Hall University School of Law in New Jersey. Professor Lubin is an internationally recognized expert on corporate restructuring. He wrote a paper on Puerto Rico's Recovery Act entitled Puerto Rico and the Bankruptcy Clause. He has provided commentary on Puerto Rico's financial distress as a columnist for the New York Times Deal Book. This program will consist of a presentation of about 30 to 40 minutes in length. We will then respond to your questions, so please submit your questions throughout the program on the webinar panel. First, before I turn the floor over to the good professor, a little bit of background about the appeal to the Supreme Court. The governor of Puerto Rico admitted that the island Commonwealth has debt, billions of debt, maybe $72 billion of debt, that is, as to use his words, not payable in full. The island therefore adopted in June of 2014 what it entitled the Public Corporation Debt and Enforcement Recovery Act. It, in substance, was akin to Chapter 9 of the Federal Bankruptcy Code. Some bondholders immediately challenged the law, and in February of 2015, a district judge in San Juan, a federal district judge that is, held that Puerto Rico's law was preempted by Section 9031 of the Federal Bankruptcy Code. That decision, in turn, was upheld unanimously in July 2015 in the First Circuit, which has jurisdiction over appeals from the Puerto Rico District Court. That decision, although unanimous on its face, in some ways had one dissenter in the person of Circuit Judge Torruella, who could really have been read as dissenting or at least complaining about Puerto Rico's inferior treatment in our federal system. The Supreme Court granted certiorari, and the case was argued on March 22nd with a decision on Monday of this week, the 13th of June. That said, Professor, could you give us more of the background on this case and tell us what it is that the Supreme Court held in its opinion, that is to say a 5-2 opinion, with the majority opinion written by Justice Thomas?
Thanks very much, Bill, for that kind introduction. The key to the opinion in this litigation is Section 903 in Chapter 9, of course. So Section 903 arose in two parts historically. So the opening part of Section 903 was originally designed to address the 10th Amendment concerns that surrounded Chapter 9. And so that's the part that basically says the states remain in full control over their municipalities even if they go into Chapter 9. Then in 1946, the addendum part was added on to Section 903, and that's the part that now in 903.1 and 903.2. And so that 1946 addendum was in direct response to the case Fatute versus City of Ashbury Park, where the Supreme Court seemed to uphold a New Jersey state Municipal Restructuring Act despite the then recent enactment of Chapter 9. So Congress said, whoa, 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 that was not our intent. We meant that Chapter 9 would be the full show with regard to municipal bankruptcy, and so they tacked on this bit onto Section 903 that said, in essence, no more state municipal restructuring laws. The picture got further complicated in 1984 when Puerto Rico, for reasons that are still unknown, was taken out of Chapter 9. In 1984, Congress amended, or rather added, to Section 101 a definition of state, which includes Puerto Rico for all purposes except for with regard to authorizing municipalities to file under Chapter 9. So in 1984, Puerto Rico was kind of backed out of Chapter 9. And then the question becomes, does 903 still apply to Puerto Rico if it can no longer authorize its municipalities to file under Chapter 9? And as Bill, as you indicated, the Supreme Court said, yes, 903 does still apply to you, even though I think many people thought there was a good argument that Puerto Rico was out of Chapter 9 for some purposes, it was out of Chapter 9 for all purposes.
Now, Professor, let me ask you a question at this point. Was Puerto Rico, in its pitch to the Supreme Court, making a statutory interpretation argument, or were they going further into the Constitution or the, shall we say, sovereign powers of Puerto Rico, if there are any?
Well, in their briefs, they made several arguments. In oral arguments, they primarily focused just on the statutory. And that's, did allow the Supreme Court to decide this case on a fairly narrow statutory basis.
And then the decision, is it purely statutory, or does it delve into Puerto Rico's powers? I know we're getting ahead of ourselves because you haven't told us about the decision yet, but
yeah,
what's it based on?
The decision, the majority, well, even the dissent. So it's a 5-2 decision with Justice Thomas writing for the majority, and he writes the opinion on a straight statutory basis, basically says 903 applies because Congress didn't clearly intend for it not to apply. The dissent, on the other hand, says, well, if you look at the overall structure of the code, it's very odd, and you can probably tell I'm a little bit sympathetic to this argument. It's very odd to have a provision in an operative chapter of the Bankruptcy Code that applies to somebody who can't actually be under that chapter of the Bankruptcy Code. And so the dissent takes a more contextual approach, but the majority just looks in on Section 903, does the old plain meaning thing, and says it applies.
In your view, Professor, is the majority opinion really very complex, or is it really a very straightforward slam dunk approach to answering the question?
Well, they present it as a very straightforward slam dunk approach. I think what is missing, right, from the majority's opinion is any discussion of this history of Section 903 that I just described, and in particular how Section 903 came to us in two parts at two distinct points in history. And in many ways then, right, you have to think about the first part of Section 903 as being addressing these 10th Amendment concerns, and the 10th Amendment doesn't feature at all in the court's decision, right? It just does a straight statutory analysis.
Let me ask you this, Professor. At oral argument, and I think I was certainly there, I believe you were too, Justice Sotomayor, and I believe also Justice Ginsburg, who were the two dissenters, made comments to the effect that how can you deprive Puerto Rico of the ability to utilize Chapter 9 when you give them nothing in return so that they can deal with the problem that the lights may be shut off and the water might start flowing? Does the majority opinion by Justice Thomas deal with that issue?
Well, only slightly, right? So Justice Thomas says, in essence, this is Congress's problem, this isn't our problem. And so they dodge the issue, at least from the Supreme Court's side entirely. To some degree, this gets into the 10th Amendment issue that I keep alluding to. Now, obviously, Puerto Rico is not a state, so the 10th Amendment is not directly relevant to them. But in the article that you referenced that I wrote, which the First Circuit was kind enough to cite, but not the Supreme Court, I basically make the argument that maybe we should read 903 as being part of a bargain, right? And when states opt into using Chapter 9, they are also opting into the federal system, and they lose their ability to have state statutes. Applying that by analogy, right, that analysis by analogy to Puerto Rico would basically have an ability, right, to pass its own laws, at least until Congress opened the door to it using Chapter 9. But the Supreme Court really wasn't interested, at least the majority wasn't interested in going into that sort of a complex analysis. And again, they instead, just set this out as if it were a straightforward statutory analysis. According to Justice Thomas, Congress has told us states can't enact municipal bankruptcy laws. Puerto Rico is a state for this purpose. End of story.
Well, let me ask you something about what you said just then, where you said that Congress has said that states cannot enact municipal bankruptcy laws. What exactly does that mean? Does it mean they can enact laws that are, shall we say, short of what the bankruptcy code would accomplish in terms of radically restructuring debt? Or what exactly is it that Congress has prohibited the states from acting on their own?
Well, that actually was also an issue of some puzzlement, because I said, Congress enacted this addendum to Section 903 in 1946 in response to the Ashbury Park decision. There's always been some doubt among many of us, and I think this has historically been true, as to whether Congress's language actually effectively overruled Ashbury Park, because the language that Congress added to Section 903 actually didn't address the facts of the Ashbury Park decision. Because in that case, it was a New Jersey statute that actually did not provide for a discharge of any debt. It was more like a moratorium kind of statute. And the addendum to 903 actually only talks about a composition of indebtedness. So there was some question as to whether the language actually achieved the end that Congress had intended. Well, Justice Thomas doesn't address any of that. He basically just says flat out, Ashbury Park was overruled by the 1946 amendments. So if he's right in that, the Supreme Court has now said basically that, well, they're reading the 1946 amendment quite broadly to mean what Congress may have intended, even if that's not what they actually said.
Well, so in other words, as Justice Thomas was interpreting the statute, could a state have some sort of a law that affects distressed municipalities but stop short of violating the Contracts Clause of the Constitution?
Well, so the Contracts Clause is always going to be a challenge here, especially for a retroactively applied law. But in certain extreme cases, the Supreme Court has said, right, basically in times of emergency, that the Contracts Clause doesn't prohibit things like moratoriums, as long as you have a really good justification for it. You just can't do it all the time. But given some of the broad language in the majority's opinion in the Puerto Rico decision, it may not be the Contracts Clause that's going to be a problem for those kind of statutes going forward. It may be Section 903, because certainly, I mean, the court may not have really focused on this issue, but there's certainly some very broad language in the opinion that suggests all bankruptcy-like laws are off the table now.
Well, let's be very upfront about that, Professor. States are not compelled to allow their instrumentalities resort to Chapter 9. That was part of the whole constitutional mishigas decades ago.
Right.
They can opt in or they can opt out of Chapter 9, either entirely for everybody or selectively for instrumentalities. So let's take the situation of a state that has decided not to permit its municipalities to use Chapter 9.
Right.
In view of the decision from the Supreme Court in the Puerto Rico case, could a state like that enact its own laws to deal with municipal insolvency?
Justice Thomas seems to answer that question no. You know, again, going back to the article I wrote, this is part of the reason why I wanted to, or I suggested it would be better to read Section 903 as being part of a sort of Chapter 9 bargain, because then it would be something that states would be voluntarily opting into. But instead, Justice Thomas seems to read the 1946 amendments to 903 as taking away completely the power of the states to deal with municipal insolvency, whether or not they've opted into Chapter 9. Because obviously, Puerto Rico, right, has no ability to opt into Chapter 9, and it's lost its ability to address municipal insolvency.
Right. Well, let me ask you a question more particularly about Puerto Rico. Congress, of course, has a bill pending right now that would, I won't call it allow a bailout, but it would create basically a new statute, not part of the bankruptcy code, that will allow Puerto Rico to, shall we say, adjust its debt under a federal oversight. Now let's assume for a moment, Professor, that Congress does not get off the schneid and that legislation is not adopted and it's not signed by the President before there is a very major default by Puerto Rico, which could come up, I guess, even this month. Could Puerto Rico, do you think, in the event of a flat-footed default and in the absence of any federal legislation, impose something like a moratorium to keep the lights on that island?
Well, it's actually already imposed a moratorium with regard to one set of its creditors. Those, the Government Development Bank defaulted, I think it was about a month ago, and the governor imposed a moratorium there. There's a real question as to whether or not that is actually enforceable in light of things like the contracts clause, but Puerto Rico could certainly try. This recent decision certainly, though, does give one more tool into the, or maybe arrow is the more appropriate word than tool, into the quiver for the bondholders who want to challenge such a moratorium. Yeah, I mean, if Congress does not enact legislation, and in light of this decision, Puerto Rico is going to be in a rough place, because it's essentially going to be in a situation not unlike that faced by Argentina, but obviously Puerto Rico is not a separate sovereign nation, so it doesn't even have the degree of sovereign immunity that Argentina had.
Well, I mean, they can be between a rock and a hard place. Let me ask you this, Professor. Could you tell us a little bit about what the two-judge majority had to say? By the way, folks, I don't think we mentioned it already, but this was a case decided by 7 justices because Justice Scalia had died a month before this argument, and Justice Alito recused himself, so there were 7 justices who decided this case, and 2 of the justices, Sotomayor and Ginsburg, dissented. What did they have to say? What holes did they see in the majority's argument?
Well, they basically approached Section 903 in a very different way, right? They were arguing for a contextual approach rather than just reading Section 903 as it's written there on the page. They wanted to see 903 as part of a larger system, and that this was a Chapter 9 system at place here that really did not apply to Puerto Rico, and so therefore whatever 903 said was no longer relevant once you made this sort of put Chapter 9 in its broader context. So that's where they wanted to go with this argument, but again, they, as you say, were unable to convince really any of the other members of the court. And I think we've alluded to this, but we should just flat out say that this decision was a bit of a surprise, I think, for many of us who had heard oral argument where it really sounded like there were at least 4 votes, and that's all you would have needed on a 7-member court, right? It sounded like there were really 4 4 votes out there to reverse the First Circuit and send this back to at least address then the Contracts Clause issues. But so the decision instead came out as a bit of a surprise to say, no, we're actually affirming the First Circuit. I mean, it does raise the question about what was the point of granting cert when they sort of came out at the exact same place that the First Circuit had?
Yeah, well, I got to tell you, Professor, I'm with you on there. I was, shall we say, very much misinterpreted oral argument, because it was pretty clear, I think, that Justices Sotomayor and Ginsburg were on Puerto Rico's side. But from her comments, I thought that Justice Kagan was too, and probably also Justice Breyer. But Lord of mercy, we missed the boat on that. Also something else, Professor, another place where I guessed wrong. I figured they would not offer up an opinion like this, which might become moot if and when Congress adopts a statute. I mean, if Congress had already adopted a statute, say last week, this opinion in this case might well have been moot. For that reason, I thought they were going to wait until the end of the term because of a fear that, I don't want to go issuing important opinions about the power of what is almost like a colony of the U.S. if that opinion is going to become moot. But they just jumped in and threw this opinion on the table. Do you suppose that was intended to get Congress to move and do something?
I don't know. Especially given the failure to predict the outcome of this case after hearing oral argument, I'm hesitant to get into any further predictions about what the Supreme Court is up to.
Yeah. Well, that's fair enough. I guess we'll never know, but this is an interesting interaction between two of the 3 branches of our government. I must say, the only thing I guessed right, and it wasn't much, was I was guessing that Justice Thomas was going to write the opinion, and that for 2 reasons. Because number 1, he writes a lot of the court's bankruptcy opinions, and number 2, he is the only justice, I think, who had not already written an opinion from the March sitting. But
yeah, and I actually interpreted him writing the opinion as being consistent with reversal, because in the past he's expressed some skepticism about preemption, federal preemption laws. But he runs right past the preemption issue. In this case, he says there's no presumption against preemption here because we have an express statutory language from Congress, and then they're off and running with the plain meaning of Section 903.
By the way, there is major preemption litigation bubbling up through the Court of Appeals, in particular in the context of the Federal Fair Debt Collection Practices Act, where there's already a split of circuits, with some circuits holding that the bankruptcy code superseded provisions, if not all, of the FDCPA, at least with respect to bankrupt individuals. And that's an issue that well could find its way into the Supreme Court as a preemption case, perhaps not in the next term, but at least by the term that follows. Let me ask you, Professor, another question here about the states themselves. That is to say, states, as opposed to their instrumentalities, are not eligible for filing in Chapter 9. In other words, if New York or Illinois or New Jersey go bust, can't pay their own state debt, they cannot file Chapter 9.
Right.
Let me ask you this. Do you think this opinion says anything about whether a state excuse me, could adopt a law to compromise or arrange the state's own debt as opposed to the debt of an instrumentality?
Well, I don't think this opinion does. Obviously, such a law would have to deal with the Contracts Clause. But I don't think this opinion says anything about it, and I would note that Section 903 itself is really focused in on municipalities, so even the sort of the preemptive piece of Section 903 that the court was looking at here, that statutory language wouldn't really tell us much, unless Congress, of course, were to expand the reach of that Section 903.
Well, let us hope that we're not in for any surprises, and that none of our states are approaching default on their debt. But
yeah, I mean, I would point out that to some degree the states, you know, and this is a point where I've disagreed with some other academics. I'm not sure if I see the need for the states to have access to Chapter 9 because they do have sovereign, well, something like sovereign immunity. They have 11th Amendment immunity, which means it's very hard for creditors to actually collect against states anyway. So even if they do default, what's your remedy?
Professor, anything you'd like to mention with respect to the bill that is pending in Congress that would assist Puerto Rico with its debt?
Well, you know, as you pointed out, certainly one clear outcome of the Supreme Court's decision is that either we have federal legislation or we're going to have a bit of a mess, right? Partially because Puerto Rico has a very complicated debt stack. It's issued debt both at the municipal level, at the Commonwealth level, and then it's also issued all kinds of sort of funny one-off debts that are tied to specific revenue streams too, and everyone can debate as to who exactly has priority here. So without some sort of organizing statute like a bankruptcy system, it's going to be a bit of a mess. So we got this federal statute that's pending. It's passed the House. It would impose an oversight panel comprised of 7 members. And those 7 members, by a vote of 5 to 7, could put Puerto Rico into something that looks very much like bankruptcy. This is Title III of the bill, which is studiously not called bankruptcy, as Bill has pointed out, but it incorporates by reference basically all the same provisions that are incorporated by reference by Section 901 of Chapter 9. So there is a kind of a bankruptcy system in the bill. Another interesting part of this, and I think it's a very controversial part of it, is it's the oversight panel who both decides whether or not to file the bankruptcy case or the quasi-bankruptcy case, and it's also the oversight panel who gets to decide what the plan looks like, which is, I think, not going to be particularly popular in jurisdictions like Puerto Rico.
Very interesting, sort of a take it or leave it, Puerto Rico.
Yeah, and
certainly not anything like what municipalities now have under Chapter 9, where they are the only ones who can propose a plan.
Yeah, exactly. The composition of the oversight board obviously becomes very important, it would seem to me, because whoever these 7 people are, they're going to have tremendous power over Puerto Rico.
Well, you know, what you say is pointing in the direction of indicating that Puerto Rico is in some kind of a status which is at least well short of the 50 states in the Union. I hesitate to say what it is exactly, and I'm not sure anybody knows, but it's not the same as a state. That really interestingly, Professor, brings us very close to the other Puerto Rico decision that the Supreme Court decided on June 9, exactly 1 week before, or just a few days before we got the decision on the Puerto Rican debt situation. This is a case called Commonwealth of Puerto Rico versus Sanchez Valle. This is a case not having to do with debt or bankruptcy or anything of the sort, had to do with double jeopardy. It was a situation in which individuals were first prosecuted by federal prosecutors for gun possession. They pleaded guilty, and then Puerto Rico mounted its own prosecution, and they raised a double jeopardy defense to be defeated both in the Puerto Rican Supreme Court as well as in the Supreme Court in the June 9 decision that was written by Justice Kagan with 2 dissenters. Professor, would you like to tell us a little bit about this decision, especially in terms of how it speaks to Puerto Rico's sovereignty or the source of its sovereignty?
Well, it's an interesting thing. I certainly cannot profess to be any sort of double jeopardy expert, but Puerto Rico, I think, thought it had achieved some degree of sovereignty after 1950 when Congress agreed to give it its own constitution and allow for direct election by the people of Puerto Rico of its own governor, so no more presidential appointees, and to have its own legislature. And what the Supreme Court said in this double jeopardy case was, well, that may be all true, and yes, for under the common understanding of sovereignty, Puerto Rico is sovereign, but for double jeopardy purposes, it is not. And then when you sort of lay that decision next to the decision in this in the Recovery Act case that we've been talking about more fully on this discussion, it really starts to seem as though Puerto Rico is not sovereign in any way that really matters to the people of Puerto Rico. So, to the extent that they thought that they had, changed the relationship with the United States in some sort of significant way in 1950, these 2 cases instead point back to, at heart, Puerto Rico is still just a territory and subject to the control of the United States Congress.
Yeah. Well, it's a fascinating decision because the Supreme Court in the double jeopardy case points out how states, even states that came into the Union after the adoption of the Constitution back in the 18th century, nonetheless have the same sovereign power as the original 13 states. But Puerto Rico does not have what you might call the innate sovereign power either in the government itself or in the people, with the Supreme Court having told us on the 9th of June that the sovereignty of Puerto Rico is entirely the result of an act of Congress in 1950. I guess this kind of presents a question for Puerto Rico, Professor, does it not, about whether the people there would want to be independent or be a state. Do you think this decision from about double jeopardy would move Puerto Rican residents to have feelings one way or the other about independence or statehood?
Yeah, I do think that, again, taken together, both of these decisions make it pretty clear that there's not an additional category. And so to the extent that Puerto Rico thought it could create some sort of new status for itself, that the Supreme Court isn't buying that. You're either a territory or you're a state. And so, yeah, it may well open up some of these questions. I mean, there's some discussion in the double jeopardy opinion, too, about the status of the Philippines, which is actually an interesting contrast, because the Philippines was also, the United States acquired them as well during the Spanish-American War, but they obviously became fully a separate sovereign nation after World War II, and nobody doubts they could enact a bankruptcy law, right? So as you say, some Puerto Ricans might think, hey, either we need to become a full-fledged state, because then, as you say, you get full powers as if you were there at the revolution, or alternatively, we need to get independent. And certainly the Supreme Court has kind of pushed the discussion along that way. Obviously, if this legislation pending in Congress is passed and there's an oversight board that's put on, imposed on top of the Puerto Rican government, that it might also push further in this direction towards having these discussions.
Yeah. Well, I tell you, it's difficult questions like this about the status and sovereignty of Puerto Rico that had led me to think that the Supreme Court might not have reached some of these issues if they avoid them. But I tell you, they jumped into them with both feet. Also, by the way, something that I see here in these two decisions, I think, is really rather interesting. Justice Alito, before he died, was quoted as, excuse me, I'm sorry. Thank you for the correction. Had said something to the effect that he was supporting Justice Kagan for the Supreme Court. She had been the Solicitor General because he thought she was really a Supreme Court material. So we have her having written the majority decision in the Puerto Rican double jeopardy case, and we also have her in the majority in the Puerto Rico debt case. So I guess one could sort of say from that Justice Kagan is no shill for the liberal wing of the Supreme Court. I think these decisions both were ones with which Justice Scalia might have agreed with her in how she came down. We have a question, Professor, and then this is a toughie. I think you need to tighten your belt and see if you can pull this one apart. I'm going to paraphrase the question. One of our listeners says that if this bill passes Congress and is enacted, the questioner says the takings clause, not the contracts clause, but the takings clause still looms in the background. The questioner says, how do you think such claims related to the impairment of property rights and retroactivity will fare when ultimately litigated?
I think it depends who is bringing them, right? If it's bondholders generally, I think that the Congress has powers. Well, it at least has the powers under the bankruptcy clause. Now, it purports to be acting under its territory's power here, but it seems to me that Congress at least has powers under the bankruptcy clause to enact a retroactive bankruptcy law. Now, it becomes a little bit more tricky when you're talking about a significant impairment of the value of secured debt. And it gets even more tricky when you're in the municipal area because municipal bond lawyers call a lot of things secured that bankruptcy lawyers wouldn't call secured. But just to take one example, if the takings claim is brought by bondholders who have a claim against a specific revenue stream, and that's pretty close to secured debt, and they somehow lose the claim on that revenue stream, yeah, they might have a valid takings clause. But again, the value that, at least as I view it, the value that is protected, at least when Congress is enacting a law under the bankruptcy clause, the value that's protected is the value of the collateral. It is not, some sort of abstract value or value of the full face amount of the debt. So, this is the principle that's embedded in Section 506 of the Bankruptcy Code.
Right. Well, we have another question here, Professor, and if anything, boy, they're getting even more difficult. This one says that 95% of Puerto Rico's debt is issued and subject to Puerto Rico law. If there is no federal law, could you discuss how would that impact the abstention doctrine, considering that these issues have never been decided by the Puerto Rico Supreme Court, but bondholders would love to litigate in federal courts?
Right. So the question is absolutely right. That with the exception of one recent bond issuance that went out under New York law, everything else is under Puerto Rican law. I'm not enough of an expert on abstention doctrine to really figure out how that plays here. But it does raise a lot of interesting questions. But I think ultimately, right, if there is no federal law, really the key issue is going to be the contracts clause, and it seems to me that question clearly could be brought into federal court. And indeed, historically, it always was, right, back in the 1800s when the states would impose various moratoriums on debt collection, both at the state and municipal level. The way bondholders tried to get around that was they'd go to federal court and they'd get an order saying the law in question violated the contracts clause. That, of course, still didn't really help them collect any money, but they had the satisfaction of knowing that they were right, I suppose.
Yeah. Well, very often Supreme Court decisions raise more questions than they answer. In this particular case, I suppose the Supreme Court has raised the questions which we have discussed, Professor, dealing with what this decision means or may not mean. However, because it's so focused on Puerto Rico, perhaps this is one Supreme Court decision that will sort of disappear into the history books, assuming that the federal government passes a statute that Puerto Rico can effectively utilize. However, I must say that if it turns out that the United States is ever infected with declining values of assets and negative interest and things of that sort, then this issue might very well come into play if there are a flood of municipal governments that can't pay their bills, especially in states that have opted out of the federal Chapter 9 municipal bankruptcy.
Right.
But let us hope that deflation is never something that we have to worry about seriously, because our laws are really not set up very well to deal with inflation, especially bankruptcy laws. In large part, our laws assume inflation rather than deflation. Professor, this has been one very interesting discussion. I thank you very much for taking your time to talk with us today, and we invite listeners to dial up the ABI website. You can find the column that I write every day, and you can subscribe to it. Excuse me. So it's sent to you automatically by email. And what we try to do there is to tell you within a day or two about important decisions handed down anywhere in the country. Thank you very much. Good day and good luck.